My name is William Dale. I'm an attorney with the law firm of McChesney Dale in Bowie, Maryland. One of the objectives of estate planning is to avoid probate. Avoiding probate may be necessary and appropriate in some circumstances, but it may not be an important objective in other circumstances. What is probate? Probate is a court-supervised process whereby the assets of a person who has died are accumulated and then used to pay the person's bills and ultimately distributed to the beneficiaries of the person who died. Probate is not necessarily an expensive process and not necessarily a lengthy process. And I would just like to explain at least some of the features of probate so you can understand whether or not it is an issue that you need to plan around. When someone dies, if they have a will, the will generally is submitted to the orphans court or probate court or register of wills in the county in which they reside. If they have assets that do require probate, the personal representative first files a petition for probate. Personal representative is the term that used to be called executor or administrator or executrix. It's now called generally personal representative. The court filing the personal representative is required to file is a simple form, generally 3 or 4 pages, and contains information about the person who died, about whether they have a will, about what the general nature of their assets are, and about who their beneficiaries are, either listed in their will or close family members. If an individual does not have a will, probate may still be necessary, but probate would be done in accordance with what is called the laws of intestate succession. These are statutes that set forth how a person's assets are to be distributed upon his death or her death if they don't have a will. Once a petition for probate is filed with the court will issue what are called letters of administration. These are official court documents that can be used to submit to a bank or a broker or a real estate company to demonstrate that the person who has been appointed as personal representative does indeed have the authority to accumulate the assets of the person who died. Once a personal representative has received letters of administration, that person can then go to the various places where the assets are held, such as bank accounts, brokerage accounts, and present that document and take the assets and put them into the name of the estate. Generally, when an estate is opened, it's necessary for the estate to have an employer identification number issued by the Internal Revenue Service, because the estate becomes a new taxpayer for any income that occurs during the estate administration. Now, a personal representative is required to report to the court in writing what assets he or she has found that belong to the person who died, and then has to report to the court what has been done with those assets. One requirement that a personal representative must meet is that any claims against the estate must be paid from the decedent's assets. This means if there is a final credit card bill or medical expenses, or there are amounts that are owed to family members or other claims against the estate, their last bills, those need to be paid from estate assets. And once all of the assets that, or all of the bills that have been identified have been paid, then the assets can be distributed to those persons whom the decedent set forth in his or her last will and testament to receive the assets. Now, this could be a spouse, surviving spouse, or children, or it could be a trust set up by the last will and testament, or it could be a charity or other family members. If there's no will, then the state intestate intestate succession statutes would apply to determine how the assets are to be distributed. Once all of the bills are paid and the assets are distributed in accordance with the last will and testament, an accounting is filed with the court to show the court how the assets have been disposed of. And if the assets are disposed of in accordance with the last will and testament and the appropriate laws, then the court will issue an order accepting the account and closing out the estate. Generally, it's not necessary for there to be any court appearances with respect to an estate that is being probated. Almost all of the information is provided in written form and can be sent in by mail, only in a rare occasion in which there may actually be a dispute as to proper administration of the estate or proper distribution of assets would it be necessary for there to be any sort of court hearing. Generally, there are rather minimal charges that the Register of Wills or probate court imposes upon probating property. And other than the expenses of tracking down the assets and making sure that they are properly accounted for, probate does not necessarily have to be a very expensive endeavor. Whether or not it is important to you or for your loved ones to avoid probate is an issue that you can discuss with your attorney. And certain circumstances, again, really cry out to be handled privately and outside of the jurisdiction of a court. But in other circumstances, the probate process does not need to be particularly difficult or expensive. Again, discuss these issues with your attorney when you're doing your estate planning. Thank you.